am sympathetic to the argument that the subpoena on its face looked like it carried penalties based on everything that you said, but I think we have to accept for purposes of this case that it's non-self-executing, and so that it did not, in fact, at the moment of receipt, demand that you reply on pain of contempt. Would a letter have been sufficient then for ripeness under your theory? What if he had just sent a letter saying, I intend to send you a subpoena that will demand all of these documents, or just a letter requesting them that wasn't a subpoena, please turn over to me all of these documents?
So I think it depends. A letter depends on the facts and circumstances of the case. If it's a birthday card from the Attorney General that says, you know, I noticed your fundraising has just been amazing, and my fundraising could use a boost. Could you introduce me to some of your donors? That's really different from a letter like an issue in Bantam Books, which was issued under a parent state authority and demanded donor names.
So a letter could be enough?
Yes, Your Honor.
Nothing here on your theory turns on the fact that it was a subpoena?
The question, I think the subpoena makes it worse. Again, the Latin for subpoena is under penalty.
Because it shows imminence, because it shows likelihood of the likelihood that the threat will actually materialize.
Yes, and because it shows it's reasonable to be chilled.
And is it the burden of litigation? Is it the expense and the being forced to defend oneself? Because I think on the pre-enforcement theory, that is a concern, right? That the litigation expense counts as the injury, even that likelihood of the likelihood that you will incur litigation expense.
Yes, Your Honor. That's what this court held in SBA list, also alluded to it in Ex parte Younger.
But that